these articles being added to the Constitution, the answer would go the other way. Let's look at the Constitution on the commencing day.
Sir,
if suppose on that day or the next day, Parliament had made this law with regard to the right of appeal, there was no 10A then, there was no 2A then. What would you say? What would the answer be?
My answer is, and the question I think is connected to the larger question, that 185 में अपील जहाँ पे कॉन्स्टिट्यूशन ने प्रोवाइड करनी थी, कॉन्स्टिट्यूएंट असेंबली ने वो कर दी. अगर उन्होंने नहीं दी है 184(3) में, too bad. Go back, make a constitutional amendment. That is the argument, right? My contention on that is that the parliament said, yes, हम 184 में अभी नहीं दे रहे, but हम ये power दे रहे हैं legislature को कि entry 55 में हम डाल रहे हैं कि you can extend your jurisdiction if at a later stage.
The word used is not extension. The word used is enlargement.
Enlarge the jurisdiction.
Now,
yes.
how do you interpret the word enlargement? As I see it, enlargement is of something which already exists. There is no appeal which exists. So how can it be enlarged?
Mr. Zahid, there could be two interpretations to that. I mean, my loud thinking that enlargement in this entry would have two sets. One is the existing jurisdiction being enlarged. The other is creating a totally new jurisdiction. Still, the Supreme Court's jurisdiction gets enlarged. So it doesn't really matter. The express provision is required for the existing provisions, but for a new jurisdiction, you don't need any.
And when you have two fair interpretations possible, which one do you go to? You go to the one where the law will survive.
दो चीजें हैं ना, creating and in creating you are enlarging. Where is the power to create a new jurisdiction?
So that is where enlargement would come in. Most respectfully, sir.
Yeah, if we give enlargement a restrictive meaning, then can you give me an example when is it ever applicable then?
Sir,
I can't think of a scenario. Maybe you can help me think of a scenario. If we give it a restrictive meaning, the enlargement is different from creation of jurisdiction. Then where will it come into play when, let's say, this act did not exist and I asked you, please enlarge the Supreme Court's jurisdiction, what would you do?
It's a matter of semantics, you see. I mean, it's just a word in the sense that suppose if there is an appeal provided, would you not say that the jurisdiction of the Supreme Court stands enlarged? So it's just a word, I mean, and we've read the principles, widest possible interpretation. So it cannot be lost in the word.
Enlargement of jurisdiction can be read with Article 175(2) or not, because it is a case of jurisdiction. No court has any jurisdiction unless conferred by the Constitution, by or under the law. So if you read the enlargement, is it not the appellate forum is not an enlargement of jurisdiction to the original jurisdiction of Article 184(3)?
Indeed it is.
So it would be read with Article 175(2) or not, where the powers have been given.
Yes, certainly.
But the law, but the law over there would have to be a law that Parliament is capable of making. Which brings us back to the same question.
What will go back to the same?
But you see, enlargement का तो example 185 में ही दिया हुआ है, और वो जो आपके वो थे tribal areas की enlargement, वो act का नाम ही था enlargement of jurisdiction. लेकिन आपसे तो मैं सवाल कर रहा हूँ, उसका मुझे बताइए ना. आपने अभी 10A और 2A का जिक्र किया.
और एक चीज और है इसमें जाहिद साहब, मिस्टर जाहिद के अंदर आप सुन लें, फिर मैं आपको एक और चीज जवाब में बता दूं.
जो है एक बात आप कर रहे हैं कि जी पार्लियामेंट के पास शुरू से ही पावर था, उन्होंने कहा जब हमारी मर्जी होगी हम लॉ बना देंगे. इज दिस योर आर्ग्यूमेंट?
पार्लियामेंट ने उस वक्त
नहीं बनाया लॉ, ठीक है,
नहीं बनाया,
but you say that inherent in entry 55 is the power to create an appellate right of appeal in respect to 184(3). Is this your argument?
Absolutely. Yes.
Okay.
My lord,
now appeal, is it a procedural matter or is it a substantive right?
It's definitely a substantive right.
It is a substantive.
Yes.
Counsel.
So you can create a substantive right by implication.
Not by implication. I'm not creating it by implication. I am saying that the injunctions of Islam mandate that you cannot deny right of appeal. And the Honorable Supreme Court of Pakistan says that this is what the injunctions of Islam say.
Which case is that? Which case is that?
Trying to get to that PLD 1989 Supreme Court 6.
But the Honorable
Supreme Court, page 6.
Honorable Supreme Court also says that the lawmaker, if he intended to the constitution makers or framers of the constitution, if they had intended to provide an appeal, they would have done so. And if they by intention did not do so, and 185 comes after 184, then be it so. I mean, if they did not provide an appeal, and now the Constituent Assembly wants to provide an appeal, let it do so. But let it be by way of a constitutional amendment,
My Lord,
not by
another way of looking at
by stretching entry 55 out of shape.
My Lord, another way of looking at it, if we look at 184.3, वो तो इस्तेमाल ही नहीं हो रहा था. Right? Later on, it started, and that is the reason that the Parliament.
कब इस्तेमाल होना शुरू हो गया? किस आप बताइए ना जो इस्तेमाल नहीं हो रहा था? Make your point.
I'm trying.
तो चलिए आगे बढ़िए ना.
Council.
जरा आप चलते रहे ना, थोड़े आर्ग्यूमेंट्स आपके हम नोट कर लें पहले. Said साहब, प्लीज आर्ग्यूमेंट्स को बताएं.
If I may,
Said Saab, as I've understood your argument,
welcome to the full court.
entry 55 is very crucial. It gives competence to the Parliament in two ways. One is enlarging the jurisdiction. The jurisdiction which already exists, its enlargement of that. And secondly is to confer supplemental powers. That is in the context of the existing jurisdiction. So, any jurisdiction that exists that can be enlarged. It is not a creation of a new jurisdiction. And it is the existing jurisdiction which is being enlarged. It is unlike Article 185, where the original jurisdiction is of the high courts of other forums. It's only the appellate jurisdiction that has been created and vested in this court. Secondly, coming back to the question, why was there a need? If as interpreted by this court till 1988, if 184.3 had been exercised the powers the way that originally were intended by the framers of the constitution makers, there wouldn't have been a problem. The problem started after 2010, when everyone was speaking about it. The voices came from the lawyers, from everywhere, that the power was being abused, and we need to acknowledge that. So now, in that historical context, merely the jurisdiction has been enlarged.
Indeed, sir. In fact,
well, the first case that happened under 184.3 was in 1976.
but the floodgates opened later.
उसके बाद 184.3 has been exercised, yes, progressively, but then the law developed.
Yes, of course it did. So, if I may just come to page 12 of this judgment.
All of a sudden, I mean, it has been there all along in the Constitution,
Indeed.
and for the first time, the powers were exercised in 1976, and
Floodgates opened later, sir.
yes.
Mr. Zahid, please, Mr. Zahid, जब हम पढ़ते हैं आर्टिकल 175 की क्लॉज 2, तो उससे पता चलता है कि दो किस्म की जुरिस्डिक्शन हैं जो कन्फर हो रही हैं. वन इज बाय द कॉन्स्टिट्यूशन एंड सेकंड इज बाय द लॉ. तो दो किस्म की जुरिस्डिक्शन हो गई, कॉन्स्टिट्यूशनल जुरिस्डिक्शन और अकॉर्डिंग लॉ की जुरिस्डिक्शन हो गई. अब इनलार्जमेंट अगर इन दोनों में से होनी है, अगर कॉन्स्टिट्यूशनल जुरिस्डिक्शन जो है, जो 184 से लेकर 204 तक आती है जुरिस्डिक्शन, उसकी एनलार्जमेंट अगर होनी है, वुड इट बी थ्रू एन एक्ट ऑफ पार्लियामेंट और बाय अमेंडिंग द कॉन्स्टिट्यूशन? और दूसरी, अगर स्टैट्यूट की जुरिस्डिक्शन की एक्सटेंशन होनी है, तो वो क्या उस स्टैट्यूट की अमेंडमेंट के लिए एक्सटेंशन होगी, एनलार्जमेंट होगी, या वो भी एक्ट ऑफ कॉन्स्टिट्यूशन के अमेंडमेंट के लिए होगी?
अगर
ये दोनों को मिक्सअप हो रही हैं कुछ चीजें.
सर, अगर सिर्फ कॉन्स्टिट्यूशन constitutional amendment के तहत वो enlargement हो सकती है।
jurisdiction जो हैं वो 184, 185, 188, 186A, 188, 204 and 203 FE जो है शरीयत कोर्ट की, ये jurisdiction constitutions में है। इनकी अगर enlargement होनी है, can it be done by any ordinary legislation?
Sir, because otherwise you will have to read this provision in relation to enlargement as being redundant.
No, वो enlargement जो है दो तरीकों से ना, दो jurisdiction आ गई। अगर दोनों की enlargement होनी है तो एक instrument है constitution, दूसरा instrument है act of parliament। तो enlargement करें उसी तरीके से करें, उसी तरीके से करें जिस तरीके से jurisdiction आ रही है।
If we say that the jurisdiction already exists, only to the extent of enlargement has the power been given to the Parliament.
Enlargement, the concept of
we
have got bogged down in amendments to the Constitution. If, suppose, Parliament tomorrow enacts an amendment and says 184(3) is hereby repealed, ठीक है ना? अब तो कोई वो तो कर सकते हैं ना, हम फिर भी उसको देख सकते हैं
जी
या नहीं देखेंगे?
नहीं, बिल्कुल
नहीं, पता नहीं क्या करेंगे। So I'm just saying कि when we concede that power, या तो कहें कि पार्लियामेंट कर ही नहीं सकती है काम, 184(3) को डिलीट भी नहीं कर सकती, because we are saying this amendment could be brought only by way of a constitutional amendment. So Parliament says, okay, thank you very much. Now I repeal 184(3) altogether, full stop. So उस पे दूसरे arguments होंगे, is it the basic structure of the Constitution 184(3) or not? But here again back to simple things. Let's see them how they are written in the Constitution.
If I may just read.
Can you just quickly finish your argument, because we have a lot of counsel to hear.
I will, page 12 of this judgment. Page 12 of this judgment.
Which judgment?
ये जो साइड किया
PLD 1989, Supreme Court 6.
शरीयत appellate branch.
Shariat Appellate Branch.
12E.
12 का, sir, the second paragraph. As far as the question that the provisions barring the right of appeal in the defense service laws are not repugnant to the injunctions of Islam is considered, we cannot agree. This court has held that the Islamic injunctions of Adl, Qist and Ihsan warrant that an aggrieved party should be entitled to test the correctness of a decision which results in the deprivation of his livelihood. See Federation of Pakistan and Others versus Public at Large, PLD 1988, Supreme Court 202, wherein the validity of certain provisions of the West Pakistan Press and Publications Ordinance, including the provisions therein which did not permit an aggrieved party the right of appeal, was considered, and it was held that the said provisions were against the injunctions of Islam and must be amended, and the right of appeal provided. The need for testing the correctness of a decision which results in the deprivation of liberty and also livelihood would obviously be greater. The court's decision in Federation of Pakistan and Others, PLD 88, Supreme Court 202, has been reaffirmed in Federation of Pakistan General Public versus General Public, decided on 17/188. It was similarly observed. And indeed, the harshness in similar provisions of West Pakistan Press Publications Ordinance was removed by the court in the same judgment. Remedial measures were ordered. The Federal Shariat Court in its impugned judgment has also held that the right was recognized by the Holy Prophet, peace be upon him, as well as the Khulafai Rashidin, and discussed this question in great detail. Nothing has been shown to us in refutation thereof. The plea thus that barring the right of appeal does not offend the injunctions of Islam cannot be accepted. So, if we read Article 2A as if it is a substantial part of the Constitution, right of appeal accordingly has to be given effect to.
Mr. Zaid Ibrahim, the question here is not whether if an right of appeal is not presently available and it is sought to be provided, who is competent to provide the appeal? And what mode needs to be adopted to do that? Now, one argument is that it can be provided by way of a legislative instrument, by an act of the Parliament. The other argument is no, because it has its genesis in a constitutional provision. Only a constitutional amendment would provide such right. And if you would read Baz Muhammad Kakir's case, in which it was specifically said where the Constitution or a statute does not provide a right of appeal, there is no right of appeal. And if you want to provide a right of appeal in the Constitution in exercise of constitutional powers, those have to be provided by a constitutional amendment. And if you want to provide a right of appeal in a statute, then the statute has to be amended, because this right is a creature of the statute or the Constitution. And unless the instrument which provides the appeal, or unless the law that has to provide the appeal, it is amended, it cannot be provided by implication.
Mr. Zaid Ibrahim.
चले आप अपना पॉइंट तो बताएं ना, हम कुछ नोट ही नहीं कर रहे हैं. I'm not writing anything. I'm just hearing various queries. I mean, can you complete your submissions?
I hope.
Please complete your submissions, and then you can respond to all the queries.
In relation to
Zaid Ibrahim,
Ye, my lord.
if I may, on your reading of entry 55, would it be possible for Parliament to make a law creating an intra-court right of appeal in respect of an appeal heard by the Supreme Court under Article 185? Would that be permissible?
Your Lordship has perhaps dealt with that question, where your Lordship has even said, "Wo the line that in the end there must be an end."
No, that's review. But I'm saying, क्योंकि आप जिस तरह entry 55 को पढ़ रहे हैं ना, review का तो हमेशा ही है. And my question is, on your reading of entry 55, would it be permissible for Parliament by an act to provide for an intra-court right of appeal in respect of judgment delivered by the Supreme Court while hearing an appeal under Article 185? Would it be possible on your reading of entry 55?
My lord, that would go against the finality principle, because right of appeal against a right of appeal. But the logic is that here there is no appeal.
Enlarge करके भी तो देखिए ना, अगर ये section 5 जो है valid है, if it is intra vires, petition under 184(3) is filed, whatever happens, appeal is filed, whatever happens, there is a right of review against that.
Okay, so let me answer.
देखिए, जो intra-court appeal is original jurisdiction, never appellate jurisdiction. Intra-court appeal, so there'll be two streams. One is the original jurisdiction of the Supreme Court. When a special single judge of the High Court passes an order, that is original jurisdiction of the High Court he is exercising, provided under intra-court appeal. So that scenario may not be here at all, because 185 is already there. We are only concerned with one kind of appeal, which is 184(3) appeal, nothing more.
No, I think
I understand your Lordship's question, and let me answer it.
आप जितना broadly entry number 55 को पढ़ रहे हैं, तो उसकी implications है ना. अगर उसकी implications fail कर जाती हैं, तो that's one thing. उसकी implications alive रहती हैं. तो इसलिए समझने की बात है ना. या तो आपका केस है कि जी appellate jurisdiction में नहीं हो सकता, further ये power खत्म हो गया, मुझे तो फिर नजर नहीं आता उसमें कोई ऐसी limit.
मैं ये नहीं कह रहा. मैं वाज़ेह तौर पे ये कह रहा हूँ कि जहाँ तक power of enlargement है, that exists not just in relation to 184(3). It exists. And my answer is, the line that in the end there must be an end, unless the Parliament says so. Unless the Parliament says so. That is my.
You added words to my words.
Yes, indeed. I'm taking the liberty of adding the words, unless the Parliament says so.
I may or may not agree with you. Subject to your.
Grateful, sir. Sir, if I may move to the next point. This challenge has been dressed up as an issue of independence of judiciary. There is a plethora of case law which identifies that how important, crucial, critical independence of judiciary is to our system. In relation to what constitutes independence of judiciary, what are the things that make up independence of judiciary? My Lord, I will not make your Lordships read, but I'll just cite the relevant paragraphs of a few judgments. My Lord, the first is the Sharaf Faridi case, PLD 1994, Supreme Court 105, at page 107.
please repeat the citation.
My Lord, PLD 1994, Supreme Court 105
At?
107.
Okay.
The second is PLD 2009, Supreme Court 879, the Sindh High Court Bar Association case, at page 1228, para 17. And lastly, PLD 2010, Supreme Court 61.
No, Supreme.
The 2010 Supreme Court?
Page 61. This is my Lord Chief Justice Iftikhar Mohammed Chaudhary versus President of Pakistan. And the relevant page is 173, para 157. My Lord, in relation to international treaties and covenants, which also define what independence of judiciary is, I have taken the liberty in my concise statement in paragraph 10. I have drawn out what these international treaties say. I will just read one sentence from there, my Lord. Independence of judiciary, according to the Council of Europe recommendations, says, the principle of independence of judiciary means independence of each individual judge should be able to act without any restriction, improper influence, pressure, threat, or interference, direct or indirect, from any authority, including authorities internal to the judiciary. This is the first day that I was able to My Lord, repeated questions have been raised, but no one has identified which fundamental right affects the petitioners, how independence of judiciary is diluted by this law. An argument is certainly made that once we open this door and allow the Parliament to legislate in relation to even the practice and procedure of the Supreme Court, tomorrow the Parliament may make another law. My Lord, when it makes another law, it will be tested whether they are interfering in the independence of judiciary. And it will be struck down if they do so, but not at present. This law does not. My Lord, most humbly, under Article 184.3.
Ibrahim, how do you say that? Where the Act obligates the Chief Justice or the two other judges to act in a certain manner, and as was rightly pointed out by one of the counsels, they are micromanaging or trying to micromanage or trying to interfere in the independence of the judiciary insofar as the Parliament will now dictate how benches are to be formed or how what cases are to be fixed by the committee or by the Chief Justice, and what would be the number of judges sitting on the benches, and how would the roster be made, and what sort of cases which go before what sort of benches. I mean, if this is not interference in the independence of the judiciary and micromanagement of the judiciary, I don't know what else would be.
My Lord,
I think this is premised. I think we should also realize that this was premised on undermining the office of the Chief Justice. Now, if the office of the Chief Justice, at least I do not read it as the same as the judiciary. I think judiciary means everyone. Chief Justice is a person. So yes, it is premised, but if I use the term independence of the judiciary by saying Chief Justice, then we should use the word independence of the Chief Justice and then not use the word judiciary. And then the argument goes back and forth. The same one is the head of the institution, so he represents the judiciary. I'm not very convinced with it. So I would say, yes, it definitely undermines the independence, or whatever better word you want to say. Use not the word independence, but some other word may be better, of the Chief Justice, but not as a judiciary as a whole.
Two very brief responses. Your Lordship should give credit when this law was being debated in Parliament. The very point that your Lordship has said was also raised. And they said...
in fact, incidentally, there are two orders of this court, and the learned Attorney General also undertook to place on record the debates,
in
which
an
have
earlier,
not been placed.
my lord, in an earlier hearing, it was pointed out that it is available online.
If that order
I think
had
it's been
complied
placed by
with,
one of the lawyers. It's available in CMA 8565. One day's debate
It's a
has been
good
placed.
150 pages.
Some parts of it have been placed
okay.
on the
Then
file.
all I was trying to point out that the questions that your Lordship has raised, the Parliament also grappled with it. And in my humble view, these matters can't be looked in an isolation. Let's face it. I do not know how cases get fixed. I do not know how benches get constituted. I don't know how 184.3.1 case gets presented on the 12th of April, and on the 13th of April it gets fixed.
So, Mr. Zahid Ibrahim,
This itself is a vindication of this law.
can be fixed by the Supreme Court itself.
So,
if you point
all
it
the
out
Parliament
to the
is saying,
Supreme Court
all the-
and the competent authority, which is the full court, which constituted, which promulgated the 1980 rules, they can revisit the rules and fix the issues.
Sir,
How does the Parliament come in?
Order
then I can
19
add-
of the Supreme Court rules, Order 19 of the Supreme Court rules says that all appeals filed in the registry shall, as far as possible, be heard in the order in which they are set down.
Okay.
Does
So
it
it's a
happen?
question of
I mean-
implementation. So according to you, the rules are already there; they are not implemented.
No,
So if it is incorporated in a statute, it would ensure implementation.
It is not incorporated in the
Mr. Zahid
statute.
Ibrahim, there seems to be a great fear regarding open door syndrome thing that's going on. So in this case, what we have to identify is whether there is a door or not. So if there is a door, there could come a law which could strengthen my jurisdiction, violates fundamental rights, access to justice, independence. I strike it down. So what's the fear? What is this open door syndrome going on?
It's a red herring.
And again, Mr. Zahid
The
Ibrahim,
main question is
Mr. Zahid
the main
Ibrahim,
question
all
here
that,
is
all
whether
that
there
the
is a
Parliament has
door.
done.
Yeah, door is the question that will determine.
The Constitution, for the
Zahid-
time being,
Zahid Ibrahim.
does not give a door to the executive or the legislature to interfere in the internal affairs of the Supreme Court.
So this bench has to determine whether it all is a door or not.
Mr.
What comes
Zahid
through the door
Ibrahim,
is not my problem.
I think these proceedings are a classic example of how the jurisdiction or the power was exercised by the Chief Justice. As I pointed out earlier, there are a lot more important cases which never get a turn. Now here, everyone is saying it's a good law, but everyone fears this open door syndrome, as my learned brother has stated. I view it differently. The Parliament, since this court, having the power under Article 191, was even refusing to call a meeting of full court. And all that they did was to structure the discretion. They have not given any directions, and all that they have done is tried to structure the discretion, which this court was refusing to do, and there were obvious abuses.
And the unstructured discretion, my lord, we can close our eyes, but the public confidence in the judiciary has eroded. And we are all invested in this.
I think, Mr. Ibrahim, if I may ask you a question, assuming that this law is, I'm looking at the practice and procedure bits of it now, assuming that this law is intra vires the Constitution, in light of this law, who is the master of the roster?
Well, according to one judgment,
No. I'm talking of the law. In light of this law, who is the master of the
I'm
roster?
not sure where the term even master of roster comes from.
Who decides which cases get fixed where, etc., etc.
The committee decides. The committee.
No, you're wrong. Committee is the creature and creation of Parliament. At its broadest level, this law is a claim by Parliament that Parliament is the master of the roster. And I'm asking you a question. You don't have to, as already pointed out by the Honorable Chief Justice, you don't have to agree with the question. To me, this is the crucial aspect of this law. It is not whether the committee consists of 3 judges or 5 judges, or Parliament says let the full court do it, or let the Chief Justice do it. Those variations, as has been pointed out, you said it, maybe those laws will be made, maybe they won't be made, that's speculative. Whether it is speculative or not, I put that to one side. The point is, and this is the question I'm putting to you,
Yes, ma'am.
that in any of those scenarios, including the one that we have before us today, it is not the committee that is the master of the roster, because the committee is a creature of Parliament's will. Parliament has willed it into existence. Therefore, it is Parliament that is the master of the roster. Now, placed at that level, seems to me that this is directly in conflict, directly contrary to the principle of independence of judiciary. What would you say to that?
Then the master
I
of the
would
roster,
say- I would-
Mr. Ibrahim, can the master of the roster speak? I would add the word the purported master of the roster. When I became Chief Justice, and I looked at it earlier also, the existing rules of the Supreme Court of 1980 stipulate simply that the Chief Justice will constitute benches. Now, practice had developed, maybe it's in accordance with the rules, I can't find it, that every week, list of cases prepared, a list would go to the Chief Justice, this case would go to that judge, and this case would go to that judge, and this case would go to that judge. I have discontinued that practice. This is not even the job of the Chief Justice. This is the job of the registrar. They can be given broad outlines, first in, first out being the general principle. Then they can be fast track case.
Master of the roster. It's a collegial system that works, and that's across the board. And it's about time that we also woke up to all this, you see.
My lord,
With due respect to the master
with
here.
utmost respect, I say we need to wake up to what's outside this room.
You see, if I may add to that,
And to answer
under our system, and I don't mean to be disrespectful to anyone, masters come and masters go.
Yes.
This is not a lifetime appointment.
But while they are there,
No, just a minute. One Chief Justice may have one view of the matter, the other may have another view. And those who come, and I don't mean immediately, I'm not talking of potential Chief Justices sitting here, I'm talking even way into the future, they will do whatever they want to do. But that is not the important point. The ephemeral, fleeting, whether it's 1 year, 2 year, 3 year term of a Chief Justice, of a master, if you want to put it that way, in the more traditional sense, that is, in a sense, beside the point. The question is, within the framework of the Constitution, separation of powers, independence of judiciary, ultimately, who is the master of the roster? And can Parliament lay such a claim and not violate the Constitution? This is the ultimate question.
But if I could just bring in another dimension to this, I don't know if you've looked at this new book called Court on Trial, and they've done a data-based analysis of the Indian Supreme Court, where they say that invariably through data they've discovered that Chief Justice, if he has all the powers, he can manipulate cases. He can ensure a certain outcome. This is through data that they've presented. They've said that judges who have been dissenting, Subha Rao is one of the judges who dissented several times during his tenure as a judge, but as a Chief Justice, he never dissented because they would manage the bench. So this has been through data now established that if one person could get a bench constituted, get the judges on that bench, he could ensure the outcome. Don't you think that sort of directly hits at the core of independence of judiciary?
of course it does. And
I've also read the book that my learned colleague is talking about, and I look forward to having a very enjoyable discussion about it with him. But the thing is, if the principle, it's the principle that matters.
Yeah.
If one man can do it, maybe 3 persons can do it.
Your Lordship,
Maybe 5 persons can do it. No, if you don't like following logic to wherever it goes, then the logical answer is everything should go to the full court. But that's practically not possible.
Mr. Zaid
The
Ibrahim.
point is, the principle of the thing still stands. My question to you still stands.
I
Yes.
want to have the
Please
opportunity
that.
to answer it.
Respond करें उसको.
The answer is in two. First, I would urge your lordships to not read this law as an encroachment into the independence of the judiciary. By no stretch of imagination is this is. Even in Parliament, when this was discussed, it was discussed that the bar has wanted to do this for a long time. But challenging the legal counsel, Hamid Khan was.
Our task at that time was counterintelligence, find out spies, ISA agents, so-called. Okay, very few people get a chance to catch an ISA agent. While we were monitoring, we realized that there is one gentleman who's logging in, sending a SMS to his Pakistani, mobile, and then that other guy logs in back, and everything is happening on Yahoo chat. There is my first ISA agent. If you read your own Arthashastra, it teaches you. The sovereign has no king. Nation has no friends. It is only, interests. In international relations, there is no Vasudeva Kudumbakam. Okay, it's only Chanakya Niti. In the next 30, 40 years, there will be rapid explosion in technologies, which is unprecedented in the history of mankind. If you don't get charge of ICT domain, which is the strategic high ground of the 21st century, you're finished. Journalists are, the fourth estate, but they are organized secrets. If you are not having a company, not having your own systems is like entering the battlefield without an army. If you look at how economics have been driven, they talk about the demographic dividend. That is an economic speak. For a security guy, This demographic dividend is a youth bulge, if you look at history. So whenever there is a youth bulge in any nation, economy doesn't rapidly grow. There are only two options. You either have a major war to ensure that these people are occupied in that way, or there will be a revolution. In the intelligence school, if you ever go, they say if you have to fool the enemy, you have to fool your friends. My personal experience is if you have to fool your friends, you have to fool your family.
Namaste, Jai Hind. Welcome to another edition of ANI Podcast with Smita Prakash. Today, my guest is a military veteran who's also an academician and a tech entrepreneur. Joining me in this podcast is my colleague Ajit Dubey. Many times we hear of the narrative that an international conspiracy has been hatched against India. And many times we might dismiss it as something done by a political party against the opposition. But those in counterintelligence and those who are experts in foreign relations know that India is vulnerable to such attacks. Don't take my word for it. Listen in to this conversation that I had with the military veteran. Colonel Pavitran Rajan is credited to be one of the first officers in the Indian Army to have used cyber or internet to track and apprehend a Pakistani intelligence operative in India. Pavitran Rajan's work is in the fields of information warfare, information security and privacy, national security and international relations. Colonel Pavitran, thank you so much for coming on the show. Can I call you Colonel or...
You can call me Pavi. I always like ladies to call me Pavi.
Oh, okay. All right. Ajit and I are very honored to have you on the podcast. I'll begin by asking you about giving a broad kind of a global background about, and then we'll go on to specifics about operations. When did the war for control of information, pathways begin? And is there a war, firstly, about that? And where is India positioned in that war?
Information warfare, in some ways, is as old as mankind and civilization. And we have always been trying to influence each other when we form tribes, when we form nations. Unless that information domain is controlled, there is no nation. You can see a classic example what is happening in Pakistan. It's the information which affects you, your brain. We are emotional creatures. So now to answer this about, this was first defined by the US, that information is a domain of warfare. They are the ones who pioneered the internet. They created the internet because of their experiences in Vietnam. And in Vietnam, they had a problem of controlling populations. They realized that they had to control the Vietnamese population to win that war. And DARPA, they started off this entire, network computers and internet out of that. And what we today see is a logical fallout. And, a couple of people have, reported on this. There's a beautiful book by Yasha Levine, who has done a, sterling study on the background of the origins of the internet. And you will find, so back to 60s, I would say. And they foresaw, the West foresaw, privacy as a concept, if you look at it, was never historically, societies always wanted it to be open. When you're a kid, you will keep telling them, hey, be open about it. Okay, if you go to a village, be open about it. So privacy, how did it become a concept in the West? They foresaw the rise of network computers. They prepared their populations, put it into the education. They also prepared the other world, rest of the countries by saying they're not culturally attuned to privacy. So that narrative is what has pushed us in the West. Oh, they're culturally now aware. We are still not culturally aware. So the battle, I would say, is synonymous with the start of the internet in an organized way. But otherwise, historically, always, since the dawn of civilization, information has always been a prized possession.
So you said that DARPA created this with the idea of controlling population of Vietnam. How do computers control? How is internet supposed to control population?
Okay, so in Vietnam, if you look at the military literature, when they had to control the South Vietnamese population, because the Viet Cong was fighting guerrilla warfare, and the Americans were, they were finding it they won every battle, but they couldn't win the war. So it was a population from among which the Vietnamese were, the Viet Cong was trying to battle them. And they, herded them into villages. They started making extensive records of who is what, etc., etc., etc. How do you recognize them? How do you do that? And they realized that this is something which is very useful for computers. Computers is what it requires to, solve this issue. And there started off this movement of connected computers. And they're brilliant guys because they encourage excellence. And they foresaw that this is a domain. And later on, 2004, I'm not so good in dates. 2004 is a time where an admiral who was responsible for the transformation in the American military, he's the first one to say that cyberspace can be a domain equivalent to the ocean.